talk, I've been asked to talk, Katie and Paul asked me to speak again today about this subject. Let me get my C5. I had printed everything at the office and then promptly left it there Friday night. Never made it back, but we have, I've access to everything through my iPad at the office, so I'm able to look at what I'd like to tell you about. We get a lot of questions when I prepare a will for somebody. I'm going to naturally add, I kind of make it a part of this, do you want some end-of-life documents? And what are those? We talk about a living will, and that's what we'll talk about a lot today. We also would have a designation of healthcare surrogate. We'll talk about that. A financial power of attorney. We can spend health, and that includes some healthcare provisions. We can do that. And then finally, things that don't come to mind commonly would be the HIPAA authorization. What document? Because if you give somebody a power to make healthcare decisions for you, you probably want them to have access to your medical records to look at them and make some decisions. And because HIPAA has been so tightly regulated, the access to those records, even a spouse may have a little bit of trouble, I've heard. I think it's maybe less so with a spouse, but certainly more so when you get more distantly. And if you have no relationship with the person, it's probably impossible. So let me start with not the living will. I think we'll save that to last because that's the most complex. But let's just talk about designating a healthcare surrogate. This is pretty straightforward. You're going to, on the document, ask that or state that you want such and such, your spouse or a son or daughter, to make healthcare decisions for you when you're unable to. When you are unable to. If you're sitting there and you're talking to your doctor, it doesn't mean your son or daughter or spouse can come in and override what you want. It's when you are, thank you. It is when you are unable to make those decisions, whether it's dementia or you're in a coma, been in an auto accident, you're unconscious. That's when you need somebody to make those healthcare decisions on your behalf. So that's what this is about. And you can designate then a secondary person. Let's say you say, I want my spouse to make my healthcare decisions for me. And if she died in the auto accident, or if she's unable to make those decisions, then my backup or secondary healthcare surrogate would be my son, my friend. I've had people put in all kinds of, relationships to the person they want to make those decisions. And really quickly, I want to comment, that's an important decision. I don't think you lightly choose who is going to make your decisions for you. We're all accustomed to going to see a doctor, and we make those decisions. We talk about it. It can be really quick. I went to the doctor 2 weeks ago. It was, no, I'm not going to do that, and but somebody else may make a different decision than me, and so it's important to have somebody close enough to you that knows what you would want. So keep that in mind. Certainly a spouse, my spouse is my healthcare surrogate. She is going to make the decisions for me if I can. After that, it gets a little less clear. So what are you stating in this document? You're saying that they can authority to control and provide my personal care needs, including maintaining my customary standard of living, providing for my living place through purchase, lease, or other method, providing domestic help, skilled or non-skilled help, compensating, hiring, dismissing such persons, providing opportunities for recreation, physical exercise therapy. So it is broader than just healthcare decisions, because that is, if you were unconscious or unable or in a coma, there's still things that would have, decisions that would have to be made about living arrangements. And this document that I've used in the past is broad enough to cover those. Let's see. I like to include statements about a legal guardian, and if there's a point in time where a legal guardian needs to be appointed, we can make the statement in the document that the healthcare surrogate would be that person, would be the guardian. So if you actually have to go to court and get a guardianship report started, if you're saying this is the person to make these decisions, then the court needs to pay attention and use this document and say, okay, let's appoint the spouse of this particular child as the guardian, so a legal guardian. So that is the designation. That's the document that says this is the person who will make these decisions. And like I said, what goes in hand, number 2, would be the HIPAA authorization or release that would allow that person. So you're probably going to, if you're naming your spouse or a particular daughter as your healthcare surrogate, you're going to need to mirror that with the HIPAA release. So that's the second document. I don't know that I would really spend too much time talking about that. We all sign these things almost, you know, how they capture your signature at the doctor's office, and you don't even get to see it, but I'm sure there's something they're capturing, and it's really lengthy about their HIPAA disclosures to you. The HIPAA authorization that I've used and on a routine basis is something I really don't mess with it very often unless it's updated. Something changes about it, and I get a notice from where we subscribe to use this document. But it's basically it's saying, allow this person that I designated to access all my medical records. So do we have any questions about these 2 particular documents?
Do you recommend having one person with 1 or 2 alternates as opposed to 2 people having like the dual authority?
The dual, that's a great question. The question was, do I recommend having one person with authority and then having a successor or maybe a second successor, or having people that have co-authority to make the decisions that exist at the same time? And that's a great question because when I prepare these, that is one of the options. You can have 2 people being co-surrogates. The question I will ask the client almost every time is there a reason you want both to make the decision together, or do you want one child? And usually it's going to come up in the context of not a spouse. You're going to make your spouse probably the sole healthcare surrogate. But if your spouse is unavailable, then maybe you have 2 children, you want them to make it together. And the question I'll ask is which one is available, which one would be more likely to make the health care decisions that you want. And I think if they're equal, then equally qualified, I can say, sure, let's name them both. Frequently, I guess the last 1 or 2 times I've heard this, it was one child was local and one child was like in California. So I think the decision kind of fell to, I'm going to have the child that was local. So, yes.
I have a quick question. What would happen if someone does not have a medical power of attorney in place? Like if you have a grandparent that's totally cognitively okay now, but then something happens and they're not, and they don't have someone in place. What do you do?
Well, that's a great question. I'm sure the doctors, I mean, a spouse is going to be pretty close. Maybe Renee, you're welcome to chime in on this.
Pretty much have to go to guardianship court.
Okay.
I mean, unless, legally, doctors aren't supposed to release any information even to your spouse, legally.
That's right. Which is now, I had an incident like that about 10 years ago.
Yeah.
My husband went in for day surgery. He said, go to work, I'll call you. It'll be a little after lunchtime. He didn't call. So I called it was the day surgery at Central Baptist. Well, he's not here now. And so what it meant, I couldn't find out where he was, and the doctor's office didn't know where he was, and ended up I called the hospital to tell me where he was, and I had to threaten to call the police, and then they told me where he was.
Yeah, and then, that's why a power of attorney is an important document.
It is.
To avoid those situations, because guardianship is not a pleasant thing to do. It's available, and it can be very good. But if you've already made the decision while you're, of sound mind, that's the much better way to go.
Doesn't that guardianship take some time too?
It does.
Yeah.
You can file
Unless
for
there's an
emergency.
Yeah.
Yeah. Yes, sir.
Yeah. Since doctors and hospitals do not share a common database of information, do you have to have these on file with every doctor and every hospital?
You probably do.
Yes.
Well, not on file, I guess, okay. Possession of documents, let's talk about that real quick. All three of these documents that we'll talk about, the healthcare surrogate, the HIPAA, and the living will, the originals I recommend go be delivered to the person who is the initial the initial designee, the spouse, or if there's no spouse, the child. I think it's important that they have access to them immediately. If they, tell them to put them in a safe place where they know they're going to be. If I hold on to that document, I might be unavailable. I might not. If somebody's trying to reach me, generally people can reach me quickly, but if it's in my will safe at the office, maybe somebody can't get to it quick enough. So I tell somebody to go ahead and deliver those three documents to the spouse, let them, or you all know where they're located.
Okay, but now we have an emergency. You went in for a colonoscopy and something happened. I have a DNR. Therefore, but they don't know that because they don't have it in their records. So that says I have to put it in anytime I go for any kind of that. Or if you're taken to an emergency room, they don't have the information either.
Right. Well, and that depends, and I think that's where we're going to talk about the effect of a living will and how quickly it's acted upon. Do not resuscitate is something different than a living will.
Correct.
Okay, so.
But it's still part of that same collection of things.
It is. A DNR is, if I, have a heart attack or whatever it may be, just go ahead and let me go.
Right.
A living will, we'll spend some time. We'll get to that because I think, and that's next, right after power of attorney. Yes, go ahead.
It's a great idea, especially the healthcare power and the living will, because of everything being, online now with the hospitals and doctors. Next time you go in to your regular doctor, at least give them a copy. They usually scan it and give it back to you now. So if there is that emergency, it should be in the record. But I have folks that will travel to Florida in the winter. They take that with them. Because again, now you're in a different state. You've got a document that says Kentucky. So a lot of times people will carry those with them when they travel.
Isn't it almost routine now when you go into some kind of procedure and check-in process? Do you have either DNR or living will or something? They ask you that question.
They do, and Joe, that was really interesting. I had some surgery about 7 years ago, and it was some big folding thing that came this wide, a regular sheet, but it folded like 4 times, and it was St. Joe's, and it said all the things that the documents we prepare or Renee prepares. And so they're at least giving you the option. They hand it to you. Do you want to do this? And so yeah, if you're going in for a significant surgery, at least I know St. Joe's provides that to the patients prior to the surgery. Although it was only like an hour or two before. It wasn't, it wasn't like I had a lot of time to think about it at the time. And the only reason I went ahead and used their form was because while I prepared them for years, I'd never had one on my own. And see, that's just the way it goes. And we don't think about ourselves, and so okay. Powers of attorney. I want to spend a few minutes just talking. I think everybody, generally you all have an idea of what a power of attorney does. A financial power of attorney grants the grantor is the person signing the power of attorney, and they're authorizing or granting the right to make certain decisions, to sign my name, to do different things to the person receiving the power of attorney. And they're the attorney in fact, is one way of calling it. these documents can be drafted any number of ways. I just recently saw one that was almost 40 pages long from Florida. And I thought that was really overkill. I think I can do it in 3 pages, but I can do it in 5.
I'm a member of the Florida Bar. I worked there before I moved back home. They have extensive laws regarding financial powers of attorney there. So it's very common, and you'll see one down there. Here in Kentucky, we've tried to get some better laws in place until the banks really get behind that, but we really don't have a lot. So that's why you'll see documents there being very lengthy.
All right. Well, the first thing I'll say about this is, about a power of attorney, is that when you're granting that power to a third person, spouse or an adult child or next door neighbor, you need to know this person can sign your name. You might not agree, and it's done. You're bound. So always the caution about who you're giving the power to. You need to think about that. I certainly think they're important for people who've been in a long-term relationship. They don't feel like there's any problem. Renee, I don't know about you. People who are under 10 years of marriage and they're certainly younger, I don't really tell them they ought to have one. There's a risk I think the risk is greater that one spouse sells the house out from under. I don't know. And goes to Vegas with the money. That could probably happen anyway. Yes.
When does the power of attorney come into effect? Because it sounds like the person's okay, but this person has a power of attorney, and so they can go and sign checks. Is that what you're saying? Is that
That's right. That's right. It comes into effect unless it's a springing power of attorney. A springing power of attorney would have a provision in it that says this power of attorney is, I'm signing it, but it only comes into effect in the future when I become, and then there's conditions, disabled, unconscious, you can set the conditions. A simple general power of attorney without that springing provision becomes effective immediately. And so so you sign it, and even if I hold on to the document and don't deliver it to the person who you granted the power to, they still have that power. They might not know about it, but at some point maybe they do know about it, and they can sign it. And of course, that's what I'm always explaining to a client. Make sure you choose well as to who you trust. And that's no different than with the healthcare surrogate, right? It's who you trust to make healthcare decisions about yourself. Who do you trust to take care of your bills, pay your bills, maintain your home. Now, let me add in what is a durable power of attorney. Let's add to that. A durable power of attorney is where you add, you need to know that a general power of attorney without the durable provisions is only good until you become unconscious. Okay, this is kind of a quirk in the law, but you need to, a power of attorney is only good so long as you have the ability to grant it. And if you become unconscious, you can't grant it. The granting ability is gone. A durable provision says, notwithstanding my disability, my being unconscious, my being injured and laying in a hospital bed, this power of attorney shall continue to be effective until my death. So Renee would probably say the same thing, almost every power of attorney we draft is going to be a durable power of attorney. So I see no reason not to do that. In fact, that would cause some problems if I didn't. Lastly, we can put, I have a paragraph I sometimes include at the request of a client that also says that using the power of attorney that somebody can make healthcare decisions for me. That's kind of duplicative and counter, I think the healthcare surrogate's a better way to do it. So now the power of attorneys are generally just for everything else other than healthcare, although it's still pretty broad. Finally, I want to tell you a little bit about who can use, when a client comes, there's two things I need to tell you. I said you need to choose well who you're going to designate as a power of attorney. And if that person happens to be with, mom and dad or whoever who's signing it, I always turn to them and tell them, guess what? When you use this power of attorney, this doesn't mean you can take dad's money and go to Vegas and have a good time. You have a fiduciary obligation to exercise the power of attorney in their best interest and only in their best. In fact, it's a pretty high standard. You can't kind of use it willy-nilly and give money away, or maybe it's not give money away, enter into bad deals. And I actually saw one recently. They hired somebody to do something. They paid them way more than they should have. So it's important that the fiduciary, the attorney in fact, knows that they can't take mom's money or dad's money and go to Vegas. And I include in there, unless you have a specific provision in your power of attorney to make a gift, they can't make gifts for you. So I'm constantly telling the person holding the power, if mom or dad want to give you a gift, you may let them sign the check. You can't sign the check for them. You need to let them sign it. That's how powerful the fiduciary obligation is for the person exercising it. They must act in your best interest, the grantor's best interest. And then I wanted to say something about banks. Whenever I prepare a power of attorney for a client, I make it known that this is only good so far. Banks do not always honor the power of attorney. So if you have a bank account at PNC or Chase or whatever, and you want them to be able to sign your name, not as an owner, not putting them on as an owner of the account, you're putting them on to be the power of attorney, you need to go down to the bank, take that power of attorney with you, but I suspect, I know a couple of banks locally, they want to use their own forms. So you can have a power of attorney that I draft, but there are some banks that will say, they may look at it and say, yeah, we'll accept this power of attorney, but they have weasel clauses in there. So what are the weasel clauses? Yeah, the weasel clause is, if you revoke it, we still have 3 or 4 days to honor, we can still honor transactions 3 or 4 days after you revoke, because they need time to react to stop somebody signing checks for them. And there's a lot, and then they want indemnification. There's not a bank around here that doesn't want to be indemnified. If they mess up, you still can't sue me.
Oh, gee.
So you just need to be aware the banks are going to use their own
banks?
forms. I'm sorry.
Do you want to mention the banks?
Well, we'll go there.
In case you bank with Chase or Wells Fargo, you need to make sure there's a backup plan, because if you get in a situation and you bank with them and you don't know this, it's going to get really not good.
Yeah, okay. I didn't know about Wells Fargo. I knew about Chase, and I've had clients tell me PNC. They've had some problems, and they just want to use their own forms. That's all. That have the weasel clauses in them.
But if they use their own form, that means their own attorney has to do it, so that's an extra charge to you too, is that right?
I don't know. I'm not sure that they charge for doing that.
Are you saying that a person has to accept their form in lieu of yours?
Well, they might. Yeah, they can say we won't honor this form.
Why?
You want to use that.
What gives them the legal authority not to honor
Can I jump in?
Yeah.
a legal document?
That's why we need more laws in Kentucky.
Well, we need clear laws. Not
Yeah, and that's the
necessarily
difference of Florida. There's specific laws that say they have to accept it if it's, prepared properly. If they don't accept it, here's the penalties. So they have that. But like he's saying, I'm saying, it's kind of worth the paper it's written on. Most of the time in this area, I've not had any problems. Even with the Wells Fargo or the Chase, a lot of times they'll want certain paragraphs in there. Like they can invest in their own mutual funds is kind of a typical one. And jump in, y'all, if you see differently. A lot of times they'll want you to record it in the public records.
That's a question I had. Does a person have to have that document recorded at a courthouse, at a clerk's office, to make it a legal binding document?
No. The question was, do you have to record it at the county clerk's office to make that power of attorney a legal and binding document? The answer is no. It is legal and binding. However, for real estate transactions, let's say you've signed this, the spouse is now, you've got this power of attorney, and the spouse that granted is now in a nursing facility and cannot attend a closing. The spouse, the other spouse is ready to go to the closing, they can use that power of attorney. It has to be recorded in the county clerk's office because that's a real estate transaction. So that would be done at the time. There are other reasons you might go ahead and record it for other purposes, just to put it on the public record. I think that's usually done, those decisions to record is done on a case-by-case basis after people have left my office.
In the case you mentioned, you recorded at the time you recorded the new deed, is that right?
Right, you have to, right, to show that the wife signed her own name and then her husband's name using the power of attorney. So that power of attorney has to be recorded to show the world.
But that's, like your question, it's not required under the Kentucky statutes, but a lot of the banks feel more comfortable if you record it. And it's $17 typically, maybe $20 to record it. The weird thing is, it doesn't really protect them. You could go and revoke it the next day. I mean, how do they think that's going to be some protection? You know, legally, if you do revoke it and it's recorded, you're supposed to record that too. But you kind of see this circle going. But like I said, that's why it's written, you know, on paper. And each bank, each financial institution, I just did one with Hilliard Lyons, and they accepted it, but they wanted it recorded. So.
Hey, Renee, can I ask?
Yeah.
So, my experience part, I have an attorney out of Virginia, but all my experience has been in the JAG Corps in the Army, and we would have soldiers, I mean, hundreds of them getting ready to deploy, and they come in, all from different states, and they sit down and you do their wills, and you do their powers of attorney, and they want to name their girlfriends. And you're like, oh gosh. And you do your best to talk them out of it. And then you deal with them on the flip side when their girlfriend has sold their car and while they're in Iraq or Afghanistan and have cleaned out their bank accounts. It's terrible. But oftentimes what we were able to do is if they had a particular transaction that they needed that person or their mom to do, we would say go to that bank or go to that, whatever it may be, find out what provisions they need, and then we will draft them. Is that something that you can do? So even though they want it on their forms, if you know in advance, you can work with your own attorney to incorporate it into the power of attorney that they're drafting for you if you don't feel comfortable signing their forms. Yes,
And
that's
you can
okay.
also have a limited power of attorney.
Right.
I mean, sometimes people just need it to do one or two transactions, sell a house while someone's, out of town.
Or endorse my name on the back of a check for me and deposit the check.
But these institutions, you get into trouble if they think, like you were saying, they have their own attorneys. I've never seen that before. I don't know if anybody can hear me over here. But they'll get into issues with practice and law in Kentucky. And so that's why usually these institutions don't offer that. You know, they'll want to argue with you, we don't like this, but then they don't want to have any help to assist you, so.
Right. Go ahead, Joe, you had a question?
Power of attorney ends immediately on death of the grantor, is that correct?
Yes, upon death, to be clear, upon death, the power of attorney ceases to be a document to be used to sign then the deceased's name. And that's when you transition to a probate case. If you have a document, if you have a title to a car, the deceased had a vehicle in his or her name, and it was solely titled in their name and not with the spouse, that's when you got to go to probate court to transfer the title. So it's only up to that moment in time, which is death, for the durable power of attorney.
And then I saw a power of attorney the other day where, you have all provisions, all the things they can do, and they had the grantor initial each one of them. Do you do that? Or just
No.
sign it?
I make them broad enough to go ahead and include it. If somebody says I want to be able to handle my business, I kind of take that to mean it's going to be a broad power of attorney, a general power of attorney. I think the opposite of a general power of attorney is a limited power of attorney, and that's where you designate it's only good for this purpose, to close a real estate transaction, to whatever you want to say in it.
So a power of attorney ends at death, and the executors take over? Is that how that works?
Yes.
Okay.
And there's that maybe period of time where the executor hasn't been appointed, but very clearly, and that's another thing I'll tell the fiduciary, or I call it fiduciary, the person who's the attorney in fact, when this person passes, you can't use the power of attorney anymore. And a lot of people are, oh, now I'll go ahead and transfer mom's vehicle in my name. No, you can't.
Unless if you're the executor.
Right. Okay.
So executor can do anything as they choose?
Well, that's pretty broad, no. But an executor, once appointed by the court, you take an oath of office. That oath is to follow Kentucky law and follow the will, or obey Kentucky law and follow the will.
So an executor of a will, can they make their own decisions?
Yes.
As long as it's in the best interest of the estate, and it's in the document, and it's in the statute. They can't take the money and go to Las Vegas, like Tom said.
In fact, that's another thing that gets you in trouble.
The person is gone.
Yeah,
You have a fiduciary duty.
family members will file a lawsuit, like, I keep thinking of Anna Nicole Smith.
Well, there's a lot of, that happen, I'm gonna tell you, that happens right here in Lexington all the time. Somebody
That's
is
the one
the
I-
executor and they go, yeehaw, and I don't care about my 5 siblings and I'm on to Vegas. And, you know,
Wow.
when that comes to light, you're gonna end up in front of the judge and maybe in jail, you know, so. Really quick, I need to move on, so Father John has some time. Living will declaration. This is the hot button topic these days. If I sign up, or somebody comes to me and asks me to prepare a living will declaration, it's basically going to say, and I'm going to read this really quick, if I no longer have decisional capacity, my wishes regarding life-prolonging treatment and the administration or provision of artificially provided food and hydration are as follows. And then there's a couple of paragraphs that talk about this. If I have anytime I have a terminal condition and my one attending physician, my attending and one other physician in their discretion have determined such a condition is incurable and irreversible and will result in death within a relatively short time, and where the application of life-prolonged treatment or the administration of nutrition and hydration would serve only to artificially prolong the dying process, then I direct that such life-prolonging treatment or the administration of nutrition and hydration be withheld or withdrawn, and that I be permitted to die naturally with only the administration of medicine or the performance of any medical treatment deemed necessary to alleviate pain. Now that's the nut of a document that is going to say, that's let me die naturally. Unplug me, let me go. Now, decisional capacity, what is that all about? If it goes further. If I'm at any time I'm permanently unconscious and I'm diagnosed by my attending and one other physician, so you gotta have 2 physicians, in their discretion as having a condition that's incurable and irreversible. So maybe a traumatic brain injury, and you're laying there and you're unconscious and you're never coming back. Then I direct the removal of medical treatment and equipment which sustains life, including the requirement of a no-code or do not resuscitate order by any attending physician, and an order that medication for pain be administered, so you still get pain medicine. And I authorize the termination of life support system or systems and the non-administration or termination of medicines and drugs, even if such action shall hasten the moment of my death. That's a pretty big decision, isn't it? It's, you know, and these are, again, not anything you should take lightly. When people come to me as an attorney, not as a Catholic, and just say, this is what I want, this is what I will prepare and hand them. There are other provisions that I will offer them, but they're irrelevant to it. It's usually, you want to donate your body to science, you want to give a part of your body for research, or I do not authorize the donation of my body. And that's in this document that I'll prepare. But what you're basically saying is, you know, if I'm so far gone, I'm permanently unconscious, I'm not there anymore. My body is, I'm breathing, I'm laying in a bed, but there are no brain waves. It's that, you know, you've had a brain hemorrhage, a traumatic head injury where there is no consciousness left in you, but the paramedics made it to you quick enough and your body is still alive, that's when this document would be used to say, unplug me. Now, I'm going to let Father John speak. We're all kind of aware of the Terry Schiavo case that came out of Florida, that situation. It's been, what now, 12 years ago? It's been a while. Where there was a dispute that ran through the courts for a long period of time between the husband who wanted to unplug Terry, and remember, it wasn't just unplug her, she was alive and didn't need to breathe on her. She had the ability to breathe with her brain stem, but she, in order to kill her, had to stop giving her water and food. And that's the ethical dilemma that we face with these kinds of documents. And of course, it was her family who said, no, we want to leave her alone, we want to keep giving her food and water. And you had that fight over what was right. And we all know Terry ultimately was, they stopped giving her food and water, and she was subsequently passed. So I'll let Father John talk about that.
I didn't plan to talk about the Terry Schiavo case, but a lot of this pertains to it. There's moral principles involved when they make these decisions. The Catholic has a set of ethical religious directives when it comes to medicine, and go over some of the basics. One of the principles is that the duty to preserve life is not absolute. We may reject life-prolonging procedures that are insufficiently beneficial or excessively burdensome. Phrases like insufficiently beneficial or excessively burdensome are in the eyes of the patient, usually. Two absolutes are suicide and euthanasia are never morally acceptable. When it comes to organ donation, well, let me go back, continuing the theme of Schiavo. When they talk about determining death, there's a problem with that. The Catholic Church sees death as when the soul leaves the body. Medicine is unable to detect when the soul leaves the body. A body without a soul is a corpse. A corpse is not a human body, but was human. To have a human body requires a soul to give that matter, the body, the specificity, unity, and life which characterize the human person. And they have neurological criteria for determining death. It's basically a way of not determining when the soul leaves the body. We can't do that. But there are signs that the soul has left the body. And they determine that there's irreversible, neurological refers to the brain. They used to be called brain dead, but they don't use that term anymore because it's now accepted as death. The irreversible loss of all functions of the entire brain, including the brainstem. Now, when that happens, the deceased body may demonstrate some residual biological activities, but these are functionally meaningless. The appearance, it looks like they are, whatever those activities are involved, but they're not sustaining life, maintaining life, or prolonging life. They're just carrying on. And once death is determined, as far as like organ donations, that is encouraged, and the church supports that. And I think other things that these directives discuss pertain to the patient who's chronically ill, or the person who has to make the decisions for that particular patient. And there's a couple principles go back to more principles involving that. Another principle is totality and integrity. And basically that is saying a part of the body or one function of the body can be harmed for the good of the whole body. Like amputation, for example. is an obvious one. And another principle is ordinary versus extraordinary means of cures. There are, when the doctors give you alternative methods of procedures, some are moral, some are ordinary or proportionate. And those are things that are proven to be successful, customarily used, and in the judgment of the patient, offer reasonable hope of benefit without imposing disproportionate burdens on the patient. In extraordinary, I guess the opposite of that, disproportionate means are those that are not really proven successful, but some people might believe they are successful, are not customarily used. It's not a normal treatment issued in hospitals by doctors, or the patient does not see that condition, that treatment as being hopeful of giving any benefit to them, or involves disproportionate burdens on the patient. And the patient decides this. When it comes to disproportionate burdens and proportionate, this is in the patient's wheelhouse.
For 17 years. Is everybody going to Mass at 11:15?
I am.
Oh, well. This ends our portion.
Proportionate is, or burdens, there's 4 categories. Like one is great effort, and the example they give is an asthma sufferer is not expected to move to a different geographical region to improve health. That would be a disproportionate burden on them, or in their eyes. Severe pain, this depends on the patient's ability to endure pain. And palliative care, which is becoming more and more common, reduces this burden. Basically, it's considered disproportionate when that particular patient cannot reasonably bear it, or they themselves believe that it is unreasonable to bear that amount of pain. Another question might become, well, how much pain will they actually receive, and how much pain do they think they're going to receive when you make that decision? It seems to me like this might happen, stopping treatment that might have begun because it becomes too unbearable, the pain. And another burden would be money, financial. Patients are not expected to bankrupt themselves or their families to procure medical treatment. They're not bound to exotic cures and do everything they can to prevent the inevitable from happening. But there's also another burden, which is very personal, repugnance. Patients may have a dread of certain treatments, and especially those that would constitute a mutilation if it were not for the underlying pathology. This comes to the totality and integrity, just hurting a part of your body to save the whole. They may not want to lose that arm, even though it will save them life. They have trouble accepting that, requesting that, letting that happen. And that's tied to the free will. The patient has the will, it's their morality that's in play. They have to make those decisions. We can help them make those decisions by giving these healthcare directives, the moral law, and people to ways to look that up, or people to tell you what is acceptable and not acceptable. Now, another principle is known as double effect. This comes into play a lot. and I've touched on it already. And this covers a situation where one action or treatment you want to do, for example, on the patient, has two effects. One is the intended effect of curing the patient, and the other is like a side effect, an accidental effect. It's foreseen, but it's not intended, and it is, in their words, they say, use the term evil. There's four conditions where you can accept that treatment morally. One is that the action itself, what you are going to do, is considered good to that patient, or at least indifferent. Two, the good effect from that treatment and not the bad effect is what you want to happen. Three, the good effect is not produced by means of the bad effect. And four, there was a proportionately grave reason for permitting the bad effect. The first thing that comes to mind is, well, you'll be harmed by this, but you won't die. You'll be cured. But you might, whatever the bad effect is, you won't be 100%. You won't be in a state you were before you were to have this injury witness. Now, good action, when we're talking about the patient determining it to be a good action, it's freely chosen action. And it is wrong that it's, by its very nature, any freely chosen action that is wrong, by its very nature, cannot be justified. So there has to be intention. A freely chosen action is, they might say it's good, but if the intent is bad upon the individual, then it's not a good act. And the second condition where the intended bad or bad is not intended, we know it's going to happen. It's not going to be an accident when it happens. But it's judged to be tolerable given the situation that the patient is in. And proportionality in that fourth condition is what they compare is the good obtained from the treatment and the good lost by that treatment, cost-benefit analysis. The bad effect would be the loss, and you determine, the patient again has to decide, this is worth it, basically. So free will comes into play a lot of these things. Well, I don't have any more time, but I have those ERDs, ethical or religious directives. There's copies of them there. All of them that were pertaining to end-of-life issues were in that copy. And there's a website on the last page where the information is located. And there's also an introduction, a very brief summary of some of the principles that I mentioned regarding the morality. Fortunately, I have to leave, but I'm not going very far, so if you have any other questions, please.
Thank you. Thank you, Father.
Thank you so much. You know, when you go through all these factors, where do you think they came from? Controversy. I mean, they came from controversy, and then we've come up with these tests. The courts have come up with these tests. The bioethicists have come up with these tests. Our priests have come up, you know, our Catholic clergy, they've come up with these tests, and it's really just, you know, to help guide us. But if you think you're the one that's going to be likely making those decisions at the end, thank you, Father John, it's probably not the case, which comes full circle back to making sure whoever you are appointing as your health care attorney in fact, if you want to abide by the church's teachings, they understand that that is your wishes, or you have these conversations with them. Just if you have to go to the 11 o'clock night, go, please, by all means, please, don't let me keep. I'll just share, just 2 weeks ago, my mom has the advanced stages of dementia, and she's she just turned 80. She's healthy. She's very healthy. But You know, what kind of quality of life does she have? These are, you know, it really, I mean, for me, it challenges me as a daughter. And going back to the dignity of life, like what is the dignity of life? I could talk on this forever, but she had pneumonia. And there's 4 daughters, and you know, we have all of this in place, not as soon as we wish we had it in place, but the question came up in advance. Mom's got pneumonia. What do y'all want to do? Now she's got her daughter, that's the nurse practitioner. I handle all her legal stuff. She's very lucky that we all have taken a slice of her life. But the daughter, that's the nurse practitioner, she's the power of attorney for all of her healthcare decisions. And so I'm kind of like, hey, Bevs, Mary Beth, that's her name. That's your wheelhouse, right? But of course she wants to get buy-in. And you know, while you were talking about some of these decisions you have to make, in her case, there'd be no unplugging. It would be decisions like, do we want to give her medicine intravenously or not? That's a hard decision. If she's not responding to the oral medications, do you move forward? Because you're far from unplugging anything. She's got brain waves. She can blink, and she can, you know, what happens when she stops taking in food and water on her own? You know, are we going to artificially hydrate and feed her? Those are really hard questions, and you're at a point in time when you think you know what the answer is going to be, and then you look at it in terms of your Catholic faith, or you look at it in terms of, you know, last year I was at this point, but this year I'm feeling a little bit differently. They're hard. They're really hard decisions. So I'm really glad that you all are here, and I do encourage you to talk with your loved ones about this and get these documents drafted just for your peace of mind and for theirs. So with that, Paul, I don't know if you have anything to add.
So why are we doing this series? To get a head start on this exact situation and many more. We have great resources in the room. Katie Shepard is here at Christ the King. And if you need to reach out to her, please do through the bulletin. Tom, thank you for being here. Renee spoke last time as well. This is Renee Mussetter, also an attorney. And when you choose an attorney or whichever of these specialists that you want, interview people and choose the one that you feel most comfortable and or experienced. Also, Susan Neville is and I'm going to say it again, the travel agent for the elderly services, that really with one phone call, she can get you to whomever you wish for a wide variety of topics. Instead of having you go through the phone book or not even know who to contact, Susan will know. Our next event is on February 19th, and we're going to talk about downsizing the home, which is as difficult as taking away car keys. It's really, really difficult for parents, individuals to accumulate a lot of things through memories through an entire lifetime, and then all of a sudden draw the line. What's significant? What do I want to take with me to the retirement community, the assisted living, and what do you want to let go? It's very, very difficult. So we have someone who's an expert to come in and talk about that. The other topic is the transportation options for elderly, whether they live in a facility or their home and they can't get around anymore, the kids are away, what have you. There is a service in town that you can use to pick you up, take you on different events that you need to go, and then bring you back. So that's on February 19th. Thanks everybody for being here. If we don't have your email and you would like Tom's presentation, I could email that to you. And as funny things happen, another attorney was supposed to be here to talk about the powers of attorney. She fell ill. She's sick this morning. She sends me her presentation. Tom can't get his up, so here we are. And then Renee shows up. So that's how things happen, the power of God. Spread the word, again, to friends and family. People don't need to be Catholic to have this. Thanks for being here. God bless you all.
Thanks for doing it.